I think it's important to start off before we talk about the two main things that are happening to employers very soon, that the whole purpose of this law is designed to give people paid leave, right? And you may think that's an obvious thing to say, but it's really important to me as a lawyer because when I'm asked to evaluate, analyze, and interpret laws like this one, I always start with what's its purpose? Like, why was it written, right? That's a very, very, very important thing. Laws that are written designed to protect employers end up looking very different when they're applied by judges, whereas laws that are designed like this one to give paid leave tend to be interpreted and applied with that in mind, right? And I say that because when we get into understanding who's qualified for leave and who isn't, and that's a question down the road, judges are going to look at this and almost assume that the leave is to be covered because that's the purpose of the statute, okay? So I think it's really important to keep that in mind as we confront some of these gray areas. The purpose of the statute is to give paid leave. So I'm going to talk mostly about notification requirements, right? Because those are coming soon, and contribution requirements, because those are coming soon. What I'm not going to spend much time on, although I'm going to briefly discuss it, is what can people take leave for, right? Those are really interesting questions, and they're very important questions. But the leave requirements don't start until January of 2021. So if you have questions about the leave requirements, like, well, what if it's an aunt or an uncle and not a wife? We can talk about that after, but really, those are questions that are best left to figure out at the time people start asking for leave. Does that make sense? So I've included some stuff in the background section about the leave itself, including how much people may or may not get paid while they're on leave, eligibility requirements, so on and so forth. You can read through that, but I'm not going to spend much time on it other than to note it is a lot of leave, right? Like, it is a lot of leave. There's a number of leave statutes that currently apply to certain employers. None of them are this generous in terms of amount of leave and also the fact that it's paid. So it is a very, very, very generous leave statute. The second to last bullet point on page 1, keep in mind that the law does not apply to cities, towns, districts, and political subdivisions or their instrumentalities. So if you think you may fall into one of those categories, we should talk after this. I had a woman at the one on Tuesday with a lot of questions, and it turned out she works for a district, and that was her employer, and that was the entity she was there for. And as I understand it and read the regulations, they're not covered. So if you think you're in a quasi-public entity, and you may fall into one of those lists or one of those items, we should talk afterwards because you may be able to avoid this altogether. Does that make sense? If you're private, you're covered, regardless of size. Okay? That's a big deal. Those other leave laws I talked about sometimes have requirements for size of employer. This one doesn't. So private employers are covered regardless of size. Are we good? Can everyone hear me? Yes. Okay. So what should you do now? So now I'm at the top of page 2. You have to notify your covered individuals, okay? And I'm going to talk in a little bit about who's a covered individual. That's where we get into 1099 contractors, employees. We'll talk about that. So just hold that thought until we get to that. But your notification requirement as of June 30, 2019, you have to have given all covered individuals, again, we'll talk about that, a notice document that the state is providing. Like, it's available for download on their website. I believe Katie's given you guys that one. Okay, so can I grab that just for a second so I can show people? So you see this one here with the green bar in the upper left-hand corner. Thank you. That's the form the state is making available for download on their website for this initial notification obligation. Okay? That has to go to everybody who's covered by the law, and we'll talk about who's covered. The state, if you're reading this, the regulations and some of the materials, the state says you can create your own form if you want. I wouldn't suggest you do that. I think when the state says, here's the form we approve, I think you want to use their form, okay? So that's the first obligation you have by June 30, 2019. It only goes to covered individuals, and it can be done in electronic form. I had a client ask me at the end of one of these last week, they use Zenefits. Do people use Zenefits? Do they know what it is? It's like an online portal for HR-related documents that they get loaded to, and people can access that way and sign things. So they're a paperless HR team. And they were wondering if they could do this all electronically, and the answer is yes. It can be electronic. It can certainly be in writing, but if you guys are wondering, well, we tend to do everything electronically, that's fine, okay? It has to be signed by the recipient, and that's the initial notification requirement for that form. Any questions about that? Katie at One Berkshire, who's put together these wonderful events, and you guys should really thank her for that, because it really was her idea to get people in this room and try to get people understanding all about this. It was a great idea, and really grateful for her for doing it. She's already rolled this out at her organization. So she's given people these forms, and she's had questions come back in terms of how much is my pay going to reduce? What does this mean for me? So she's going to talk a little bit when I'm done about that experience and sort of explain, here's how I handled it. And I think that's really helpful. So, because I think an example of a situation is good. So that's the initial notification requirement. You can, for new hires, you have the option of giving it to them at time of hire or within 30 days of hire. Okay? I don't have a view that much on should you do one or the other. I think for purposes of efficiency and simplicity, I may want to make it part of the onboarding process and have these things go at once. If there's a meaningful reason for you to delay, you have that 30-day window to delay before you give them this notification form. Okay? You also have to post the poster. The best practice is break room, because that's where people congregate, but that's the poster. So that goes up in your in each of your locations. Okay? There's not a whole lot to say about that, but that's what it is. If you look at under notification, if you look at the second to last bullet point, the state, I know there's a lot of frustration surrounding this law, okay? I completely understand that. I've been doing employment law for 13 years. This is a very aggressive position to take in terms of a statute. Like it is going to be burdensome and cumbersome. Having said that, the state's provided a lot of helpful information in terms of how to comply with the law, and they even have helpful interactive components of their website that, there's a calculator that you can use that will help you with your specific situation understand what your obligations are. So I'm going to talk about the calculator later, but right now I've linked the place on the state's website where all the downloads are available. They've made the form we talked about earlier with the green bar and the poster all available for download. It's free, and I know the green bar form has been translated into multiple languages, so if you have a multilingual workforce, that's there for you. I'm not sure if the poster's been translated into multiple languages or not, but that form has. Before we leave the green bar form, as you know, some of these dates are changing pretty frequently, right? And because of that, some of the text on the green bar form is changing along with it, because some of that text is tied to dates, okay? So it's possible that if the state decides to move this forward again, which they've done before, if they do it again, that green bar form that you have now could change, because the dates are going to be looking different if the dates for the contribution requirements change. So we're going to, at the end of this one, this is the last of the three, we're going to send an email out next week, and we'll remind you of that, right? Like we're going to give you a copy of the most recent version of these talking points. We're going to give you available for download, the poster and the forms. We're going to give you links to where all these different things are. And just keep in mind that, you should be paying attention as this may change over time, okay? And my sense is if it does change in a meaningful way, we'll get you all an email that lets you know here's the change, right? Here's the new form. Does that make sense? So the penalty for failing to properly notify is $50 for the first violation and $300 for each subsequent violation. That's the penalty. So there's not a whole lot to say about that other than they intend to fine people who don't comply. And that's just with the notification part. If you violate the contribution part, which I'll talk about next, that's a different penalty. This is just if you don't post the poster, if you don't get your folks to sign the green bar form. So when we talk about the contribution, the first thing you need to keep in mind, and this is what should I do now contribution, is that all employers must start deducting from employee wages and some contractors, we're going to talk about that. Remember, this is the covered individual issue, by July 1st, 2019. Okay? So that's the date on which the state expects employers to start collecting the money that needs to be sent to the state. Does that make sense? I know there's, yes?
I just want to confirm for the first pay date that's in July, regardless of what the pay period is. Correct?
So is it, are you asking like if, well, what would happen, did everybody hear the question? What would happen if the paycheck comes later than July 1st?
Your paycheck is July 1st, but it was for a pay period in June. The contributions would start coming out on the 1st.
Yes.
Yeah.
It goes by pay date.
Yeah. Yeah. Does that answer your question? Okay. So I've put this in bold just because I think it's important, and hopefully we've already touched it, but I'm going to remind you, this is the same no matter what the size is of your workforce. The size does affect what your obligations are, but you're responsible for the contribution requirements regardless of size as of July 1, 2019. Okay? Does everybody have the flow chart? There's two. If you don't, raise your hand. Okay, is everybody looking at it? Okay. So you can see that, so I've done this a couple of different times, and I've been expressing the contribution obligations in terms of do you have 25 or more or fewer than 25 without the benefit of this flow chart. I think this flow chart is really the best way to understand what the contribution obligations are. Okay? So I think we're going to go through it, but if you take a look at it, it's telling you, depending on your size, and we're going to talk about how do I calculate my size in a second, it's telling you what the contribution obligations are and from where that money can come from. Okay? Does that make sense? So is the flow chart clear to people, or is it not clear to people? Is it not? Is anybody here looking at that and thinking, I can't make heads or tails out of this? What does it mean?
A little bit.
Okay. So are you 25 or more? You're certain about that?
Yes.
Okay. So if you're 25 or more, the contribution is going to be so you're in the top grid. So the total contribution is going to be 0.63. And if you track down to those bottom four boxes, you as the employer are obligated to cover 60% of the medical leave portion. The balance, which is 40% of the medical leave, and then the family leave part can come from the individual's money, wages. Does that make sense? Before I move on, that's the big difference, right? So if you look at the under 25, see that gray box? That doesn't happen. Like that amount of money doesn't get flowed to the state. So that 60% that the 25 or more has to kick in, on the fewer than 25, nobody kicks that in.
Can I ask a question about that?
Yeah.
I do books for 3 general contractors. I looked at last year's numbers of employees and subs, okay? One employer definitely does not have to contribute, okay? Total of way less than that. One had 20 last year, but may have more this year by the end of the year. One had 25 exactly last year.
Okay.
What do I do if 3/4 of the way through the year I'm suddenly over that threshold?
So I'm going to address counting to 25 later. We're going to address how you count and how you get to that 25 figure. I can answer that, but I want to do it with the other parts that flow into it. Okay, so we're going to definitely cover that. I saw a couple hands. I think this is really helpful. I really think we're going to talk about contractors and counting to 25 in a minute. But once you get some clarity and comfort level with counting correctly in terms of am I 25, 26, 27, am I 8, am I 9, we're going to talk about that. But once you get clarity on that, this is telling you what your contribution obligations are. Okay? Yes?
Can I just clarify, the companies that are under 25, they're going to be paying less into this fund for medical
That's exactly right.
than larger companies?
Correct.
But the people who work for smaller companies are going to get the same benefit?
Correct.
Isn't it that the employees for smaller companies will be making up the difference?
So the employees, no, the 60% of medical for fewer than 25 doesn't get passed on from the entity to the state. That's why the box is gray.
But regardless, the organization has to pay, someone has to pay 0.63%.
No. The 0.63 is reduced for those that are smaller than 25. Yeah.
Every employer, regardless of size, will be, there will be a company cost. Is that true?
Well, let's define cost. I mean, you're going to have a cost of people taking leave, but in terms of the contribution, no.
Okay.
If it's fewer than 25, the entity can flow the cost in its entirety to the employee. Yes.
Can you give an example of the contributions in dollars, so just for like a $10,000, just give it in a round number, how much a company would contribute?
I will actually, I'll discuss that when I do my
Oh, good.
study about what we did.
Perfect.
Okay.
Katie will cover that when I'm done. Yes.
So I'm looking at this correctly, it says 0.63%, but when you come to the final thing, it's really 40% and 11%, so a total of 51% is what the contribution is going to be.
I'm not going to do that math but I will tell you that it's not 0.63 for those fewer than 25, which I think is personally the source of considerable confusion, because the 0.63 looks like the net contribution, but it isn't for those fewer than 25. So here's where I'm going to plug the calculator. When we send the email, we'll link the calculator. And the calculator is a place where it asks you to put in your W-2s and your qualifying contractors. We're going to talk about which ones those are in a minute. But it asks you to put them in. And then you hit enter. And it pulls up your contribution obligation. And it tells you, because it knows your size, that part of it doesn't need to be paid, because it knows based on what you've put in that you're under 25. Yes?
So this breaks it out based on what the minimum contribution is. If the employer chooses to pay the employee portion or some part of that, is there any tax implications to the employees for that?
That's a great question for an accountant. I don't.
They haven't been able to answer it either.
Yeah, well, I certainly. I mean,
So no one's been able to answer it. So I actually am a payroll provider.
So what's the question? The question is if the employer. Okay, go ahead.
If the employer chooses
Yeah.
to pay part of the employee contribution.
Yep.
Is there any tax implication? So is that now considered a benefit?
The IRS has not
Yeah.
made that declaration yet. That's why
So
nobody's
will
been
they
able to
know
answer.
prior to July?
So, and it's not just that. Katie's totally right. The state has asked the IRS for guidance on that, and then there's another question about how do the benefits get taxed when a recipient gets them, and is it different if they paid in or not? But in terms of that, the IRS is hopefully going to issue guidance, and I'm completely with you that hopefully they do it before this starts.
Do we know if the deduction is going to be pre-tax or post-tax?
I think it's pre-tax, but I don't.
It's another one the IRS
Yeah.
is still waiting to
Yeah.
make their decision on. So the IRS is holding up all the tax decisions.
So I think the assumption is that at this point is that it's like a FICA and Medicare where it's on the full set of wages
Yes.
first. That's until we
That's
get
what the
guidance,
state's
that's how we
saying
have to
is
do it.
until the IRS makes the decision, you are to do it pre-tax, so it's just like all the other tax. It comes out on the gross wages, not on the net.
Sorry, I feel for you. That's a tough position to be in. They haven't really given that guidance yet.
At this point, you would take it out just like you do the federal and Medicare, Social Security, all state tax, all of those income taxes.
I mean, if it means anything to the accountants in the room, according to the regulations, it's to come out of the gross wages. So for the pre-tax, post-tax, that tells me where it comes out of.
You've talked about the frustration with the law. Does that frustration fall with the bigger companies who are taking on the bigger portion, or the employees that are going to be having wages deducted?
It's not with the employees, in my experience. So my firm represents individuals in a lot of claims that are related to medical events and taking leave. My view, based on talking to those folks for years, is this is a very welcome thing for them, and they're going to be happy to pay for part of it. I don't think there's going to be a lot of, so on the employer side, there's exasperation and frustration, and I think on behalf of both sizes, I think smallers tend to ask real important questions, like if I have two folks in my business and one needs to go out for an extended period of time, that's really tough for me to absorb. That's probably not the same issue with the larger folks, right? Because they tend to be able to absorb absences a little more easily, but they're also paying. So that's the source of their frustration.
Yes. So looking at this flow chart, I thought it made sense to me until I think about it some more. The top line says 0.63 payroll deduction. The bottom line adds all four boxes up, but includes a large employer contribution.
Correct.
So does that mean we're not taking all 0.63% out of the payroll? We're taking less out?
For the 25 or more?
Yes.
Yes. The employer covers part of the contribution for the 25 or more.
So the employee is not going to get a 0.63% payroll deduction. They're going to get less than that of the deduction.
Yeah. Because the part of the 0.63 is going to be paid directly by the employer, and it's not going to come out of the individual's wages.
Oh, okay.
Yeah.
Somehow I thought we had to pay in addition to the 0.63.
No. You pay a part of the 0.63 for the 25 or fewer.
For the 25.
Sorry, 25 or more. 25 or more, yeah.
We currently offer 4 weeks paid parental leave, 100% paid by the employer.
Yes.
And now I'm thinking I actually should consider eliminating that, because if they took 4 weeks paid by us and then 12 weeks for a child, now they're at 16 total, which is more than FMLA. Anyway.
So two things there. The regulations specifically allow you to count leave under this law, leave under the FMLA, leave under the earned sick time law, and leave under the mass parental leave law concurrently. So you could count the 4 along with counting to the 12. The law allows you to prevent stacking in that regard. Okay? But I think an issue for somebody in your situation who's providing already benefits that start to look like, because you're paying and you don't have to, right? So once you're starting to provide benefits that look similar to what's happening here, there is a process to apply for an exemption. And this is getting pretty popular right now. I've had 3 clients contact me in the last week about the exemption process. Just to cover one thing that we didn't talk about when I was talking about the flow chart, the amount of gross wages on which you deduct is capped at $132,900 per individual, which my understanding is that's the cap for Social Security purposes as well, and I believe it's tied to that. Separately, now's a good time to contact and start working with your payroll companies if you use a third party to do that, because they're going to be a very big part of the logistical side of this. So I would start that process soon. So we know that 25 is a very important number in this calculation. It's very clear that that's right. That's the centerpiece of the flow chart. So the question we're getting quite a bit is we know we have to count W-2'd employees when we figure out the 25, but what do we do with contractors? Right? Are people with me on that? Just on that general idea? Okay. So what the regulations say is you have to count self-employed individuals, now we're talking about the contractor piece, okay? And according to the regulations, self-employed individuals are those with whom, top bullet point, second from the top on page 3. Self-employed individuals are those with whom you contracted and were required to report the payment on an IRS Form 1099 that also reside in Massachusetts. So if you have W-2 employees, right? We're just going to count them. We're going to come over here, and with our non-employees, you're going to look for self-employed individuals, okay? And the regulations tell us those are people that you issued a 1099, that you were required to issue a 1099, and that reside in Massachusetts. Okay, so I met with a client it was earlier this week, and they have employees, they count them, and then they were wondering, well, what do we do with our non-employees with whom we contract? And they figured out who are we required to issue a 1099 to, and they had a chunk of sole proprietors that they were issuing 1099s to. They figured out which ones of those lived in Mass, and those people are being counted. Okay? But only if they make up, can I just get one? Yeah, only if they make up at least 50% of your workforce. Okay? So if you have 30, right? Do you understand how to at least get a number of non-employees? 1099, Mass residents. And if you're not clear on who you are required to issue a 1099 to, that's an accountant question. But there are certain entities where their corporate form is disregarded and they get a 1099. Sole proprietor is one, okay? So if you're required to issue a 1099 and they reside in Mass, you should be counting them and only count them for the 25 purpose if they make up more than 50% of your total workforce. Does that part make sense? Yes.
I have a question on what means workforce, because if I had someone paint my building last year and they were a 1099, they don't do part of my business. Do I consider them part of my workforce? I had a 1099 them because it was more than $600.
I would count them, but are they going to make up more than 50% of your workforce? Because if they're not, then it's never going to matter. So the ones that I went through with this client the other day, she has 57 full-time employees, and she was counting her non-employee contractors. She got her 1099 number. She got the ones that were 1099 and lived in Mass, and there was 8. So it really doesn't matter, right? So you're really looking at the comparison and only when these make more than 50% of your workforce are you counting them for 25 purposes.
So for another example, I have 2 employees for the regular business.
Okay.
I have a bookkeeper and an accountant who are both sole proprietors. So I have to 1099 both the bookkeeper and the accountant. They're now 50% of my workforce.
I think that's what that is, yeah. We have personally, we have a very small, go ahead. Yeah, go ahead.
And I guess I just wanted to kind of ask too, many businesses give 1099s to law firms. Okay, they're based in Massachusetts, but those are, you said the other part of it has to be a sole proprietor?
No, it has to be an entity that you are required to give a 1099 to, of which a sole proprietor in some circumstances is one.
Okay, so what about a law firm that's in Springfield that is 1099?
So when I went to a training and the state was there, because this was one of the ones that has bothered me from day one, it's only if they're self-employed. So if they have employees, you do not have to do it. I will discuss that during my case study part of it, because we're going to take our W-9s and stuff further so that we have backup to that.
Is there any guidance on 50% being number of work hours or physical bodies?
It's bodies. And I'm glad you asked that, because when you're counting your employees for purposes of deciding if your 1099s are more than half, you're counting everyone, full-time, part-time, seasonal, unionized, you're counting them by pay period.
The pay that people receive while they're on this leave is capped at $850 a week, but otherwise, is it supposed to be equal to their normal wages? Or
No,
is it
it's
60%?
There's a calculation. It depends. I think the first 50 of the average weekly wage gets treated one way, and the next 50 differently. But I mean, that's a January 2021. But there is specific guidance on how that's going to be calculated.
Okay, I'm just trying to think if my plan was as generous.
Oh, if you're going to go for the exemption, you would absolutely have to drill down on that. Yeah. Okay. Yes.
So I have the same question that she just asked, but your answer did not clarify.
Okay.
Because what she said is that, when you're figuring out 1099, you have 2 employees.
Yes.
And you have 6 or 7 or 8 people who are maybe very small amounts of money, and she pays them a 1099, but they count as an employee, even if you only pay them $1,000?
No, they don't count as an employee ever. They count as they may count as a covered individual. Yeah, they may count as.
You're counting per person, not, if you're counting as workforce, just the people on the amount of workforce in terms of dollars.
Correct. And there's a separate, right? So like right now we're just trying to figure out when I count to 25, that's next, okay? Do I count 1099s or not? So we're going to talk about whether they count for 25 purposes in a moment, but whether or not you have to count them depends on if they make up more than half of your workforce, which is your situation. Does that make sense? So if you count your employees and you have 50, and you count your independent contractors or 1099s that reside in Mass, and you have 6, when you count to 25, they're not in because they don't make up half.
Is there any difference for employees' residential address?
No.
So an employee lives in New York State.
Works in
counts as
Mass.
an employee, Works in Mass.
Yeah.
Will they be eligible for the benefits?
Yes. There's specific, I think, on the top of page, the state, towards, it's the last bullet point before we get into exemption. I've included what the gut regulations are saying for these transitory issues. I live in Mass, I work in New York. I live in New York, I work in Mass. I live in New York, I sometimes work in New York, I sometimes work in Mass. I think those are going to be moving targets. So I think if you have those situations, you're really going to have to dig in and run those folks through, do they count for this purpose, understanding that the different state issue is complicated. It isn't a yes or no. Yeah.
Once I make this decision, how many employees or covered individuals I have, do I make this decision for the year?
We're going to talk.
Do I do it quarterly?
We're going to talk about calculating 25, okay. And there's a concept called total average workforce. And so what it's basically telling you to do, we'll just do it now. So it's basically telling you that you're going to want to go back in time and count, right? So when I did it with my client earlier this week, she created a spreadsheet with 2 tabs. Tab 1 was W-2s for 2018 and 19, okay, by pay period, because that's how the regulations tell us to figure out if you're 25 or not. And then separate tab was her 1099s, Mass residents, right? She's not counting those. And then we averaged the W-2s to come up with a number, and that's how you figure out if you're 25 or not.
And then you carry that through the year of 2019?
Yeah.
And then you do it again for 2020?
Yeah, I mean, yeah, annually you can revisit the calculation.
And once you make that decision for the year, you have to stay with that?
Yep.
No matter what the changes or?
Currently, my understanding is once you make that 25 calculation for purposes of like on July 1, that's what's going to happen going forward for the duration of 2019.
So
Even if you dip, yeah,
you're stuck with it.
right. And then it revisits annually. And just as an aside, I think that average idea they came up with that to try to account for seasonal businesses that spike dramatically, which happens a lot here. Ski areas and summer folks, they spike dramatically in certain months and then fall off a cliff in other months. So they've tried to accommodate that by using an average concept. We're going to talk about counting to 25 in a second. But the cornerstone of whether or not, of how you count to 25 is if you're counting your 1099s when you do it, right? And remember, we're only doing that if the 1099s that reside in Mass make up more than 50% of your total workforce. Okay? Everybody got that part? So now that now you're trying to determine, okay, I figured out my W-2s. I either have to or I don't have to count a certain amount of 1099s, right? And then you're wondering, well, how do I determine if it's 25 or not? And the regulations say that you do exactly what I just said, which is you want to go. I think the best practice would be to do 2018, year-to-date 2019, each one of them for each pay period. Add that and divide by the number of pay periods, and that's going to give you an average.
For employees.
No, that's for covered individuals. So,
But maybe your subcontractors, they don't have pay periods.
so the question is, what about subcontractors who don't have pay periods, right? So, in my view, I would, and this is what I would count them on the pay period when you pay them. So, and there's going to be a situation where somebody may have worked 2 weeks or 3 weeks or 4 weeks and gets paid at the end. That's them being paid during that pay period. So I would count them for that purpose. If you have to count 1099s. Remember, you don't have to if the 1099 Mass residents don't make up at least 50% of your workforce. Yes?
So if you had like a big project and you were hiring a bunch of 1099 employees for like a capital project, capital improvements or something, you could actually 1 year be paying, your employees could be paying the full portion of this paid family medical leave, but then the following year, like you could revert back and forth year to year, whether or not the employer has to kick in?
The determination as to whether the employer has to kick in is a function of the number of covered individuals. If that fluctuates year to year, the obligations are going to change. Yeah. So that's how you figure out if I have 25 or not, right? The first step is look at my W-2s in relation to my contractors, my 1099 Mass resident ones, right? And then if I have to count those, then I'm adding all those up by pay period, and I'm adding up the numbers and dividing by the pay period. Yes.
Just to follow up on her question, is there going to be some kind of like auditing process to make sure that like these companies are counting everyone and all the 1099 people correctly?
So my understanding is that you're going to be required to submit total workforce numbers to the state as part of this, and then they're going to be able to understand your contribution numbers, and they'll be able to determine if you have that part right. There's a submission requirement to the state of total workforce. Yes.
How would you count? So we pay self-employed people, but we pay them via an online platform, which facilitates the financial transaction, but they don't work for that platform.
Okay.
So I'm not paying them directly, I'm paying them through a company, but they don't work for that company.
Okay.
So would I not count them? Would they not be?
So the question, for those of you who couldn't hear it, is what if I'm an entity that pays a third party through an intermediary sort of thing? Is that? So the way to resolve that is a complicated legal question, right? Who's the employer comes up in a number of different contexts, especially in staffing situations with temp agencies. Who's technically the employer when I engage a staffing company to provide me with an employee for a period of time, and then let's say that employee brings an overtime claim. Well, who's the employer for that purpose? So that's complicated. I'd have to know more about how the relationship is structured, and I think from a best practice, want to have the document between me and that intermediary address that issue, and I would want it to say, for purposes of PFML, right? You're the employer, not me, and you will indemnify me if you calculate wrong. I would be addressing it that way. In terms of who's the legal employer, that gets complicated.
So if contractors make up 50% or more of your workforce, are you then deducting the tax from the 1099 payment that you're making to that individual?
Yes, I just want to
And it's
clarify.
the exact opposite if it's less than 50% of your workforce, are you not
You're not.
taxing the
Right.
1099 contractor?
Correct.
Okay.
But just to make it clear, I just want to reemphasize, we're talking about entities, individuals that you're required to give a 1099 to that reside in Mass. I think the word contractor can get loose, right? What it really is somebody you need to give a 1099 to that resides in Mass. But otherwise, yes. Yep.
I hadn't seen any of the documentation. Is Massachusetts prepared for 2 independent filings if payroll is being done by a third party in filing and contractors are, say, being paid by a bookkeeper separately? And those 2 numbers technically need to come together in one quarterly filing.
I'm not equipped to answer what Massachusetts is required or is prepared for. So that's an easy answer. I don't know. Katie raised her hand though because she's gone to a lot of these state presentations, so she might have an answer.
In one of the trainings I went to, the state was explaining what Mass Tax Connect's gonna look like for us, and it's just gonna be one lump sum. So people that do have to count their 1099 are going to have to submit their payroll numbers too, because if you don't pay their 1099, then can't know that. Because it's just a lump sum that says one Berkshire paid out $1 million and has to pay the state.
So employers are now going to be responsible for submitting wages to the state on a quarterly basis?
For
Or unless they
this.
choose to give that number to the payroll provider. to
Correct.
file.
Payroll provider.
So I realize we're covering a lot, but if you read through the materials, I've tried to distill the variables into the important components. So as you walk through the 25 process, there's a couple of steps, and they're spelled out. So I hope you find that helpful. Are there and the calculator again, like it's out there, and it's designed for you to plug these different variables in, and it tells you, it spits it out, and tells you you're not 25 or more because your 1099 mass resident contractors don't make it. It'll tell you that. It's just the issue is counting them correctly. Yes.
Just one more question on the contractors or subcontractors or whatever you want to call them. We have a few of them that work for us in Massachusetts, but their business is out of state. That wouldn't be considered
Well, are you issuing a 1099?
to their company that lives in, say, New Hampshire, that comes out of New Hampshire, but comes to work for us in the state?
Where does the individual live?
It's not so much an individual, it's a company.
And the company resides in New Hampshire? And you don't know where the individuals that are performing the services live?
Because 1099 is being issued to the company itself, not the individuals.
Do you? Yeah, my first instinct is I don't know that an entity like that gets a 1099, is required to get one.
Well, if
That's
they're an LLC, they would.
well, if yeah, I understand. A single member, some LLCs do get 1099s. Yeah, I acknowledge
You
that.
don't even have to be a single member LLC to get a 1099.
I can answer that. So, the way the state told me is that where you mail the 1099 is where you count their residency. So if it's not in Massachusetts, if you're mailing it to New Hampshire, then they do not count. But if they have employees, they do not count. So if you're sending one to a company that has employees that comes and does it, you don't have to count them anyway.
At the top of page 4, I'm including this just so to remind people. This is an email from the state that came out on May 21st. And you can read it, but basically it says, we continue to provide more information. Translation, we know this is confusing. We haven't got this right. We're still trying to clarify it. So that's happening. And it's happening on these core issues that we're talking about in terms of what you were asking, right? And they recognize it, and they're working on more answers to these types of questions. An entity in New Hampshire, these sorts of things. Yeah.
Follow up with
sign off on.
Yeah.
Are we gonna have them re-sign all of the changes that they're gonna make?
So before I lose the thought, just a reminder, if the state issues meaningful updates in the next week and you've given your email address to Katie, you'll get those. In terms of your question, it would depend on what the change is. I mean, in my view, if a client came to me and said, I know there's a new form, but it really just changed the color of the green bar, I probably, but if it's a substantive change,
Like the date people can start collecting or any of that?
yeah, I think if it's a substantive change like that, the best practice would be to re-up the document. And I think that's just, yeah. Yes.
Because this has caused issues in the past with school districts,
Yeah.
the law specifies cities, towns, instruments of the state.
Yeah.
Does that also include regional school districts as being exempt from this requirement?
So that's a really good question. The law says what it says. I've copied it verbatim in this. The answer to that would be determined by understanding how courts have evaluated the word district when compared to a regional school district. So my sense is it's a yes, but I would want to research that specific question. Does that?
So the state, check with the state?
Or a lawyer. I mean, the answer is when a statute uses the word district, do they mean regional school district? And the answer to that will be determined by how judges have interpreted the word district before when it appears in other statutes.
Okay. We're running out of time, so
Okay.
we can wrap it up, and I'll do my case study and we can answer questions afterwards.
Okay, so I'm going to go through the exemption quickly then. Bottom of page 4, top of page 5. So this is going towards what you were asking. If you have the ability or the capacity to provide these sorts of benefits and they're equivalent, like on every meaningful point, and you can provide them on your own, you can apply for an exemption from this entire law. So where I'm seeing this happen with some of my clients is they offer short-term disability, they offer long-term disability, and they're trying to do a cost-benefit analysis on how much does it cost for us to make that package equal this, and how much would it cost for us just to do this? And they're trying to figure out what's better from an economic standpoint. I will tell you that insurance companies are beginning to look at writing policies that will match these benefits. I have 2 clients right now that are working with their insurance company to take their short-term, long-term and bridge the gap to get it to this. And that insurance company is working on it and they're going to price it. And then eventually that company will decide, should we just buy that extra coverage and provide it on our own? So if you're already offering short-term, long-term, it might be worth the time to figure out, okay, how much more do I pay to provide it all in-house? Does that make sense?
If the short term, like we offer, well, we don't offer, it's voluntary, so the employees pay their short-term disability, that does not move because the company doesn't pay for it, correct?
You'd have to match it completely. So it would have to be everybody that should be covered under the law would have to be covered under your short-term, long-term in the exact same ways. In terms of weekly benefit, which you were asking, and in terms of how much leave I get and why I get leave, retaliation protections, there's a host of things that it'd have to match on.
And that would include your 1099 subcontractors?
Yeah. Because remember, the purpose, to close where we started, is to make sure people get paid leave, right? That's the objective.
So I'll quickly go over because we're right at 10. So at One Berkshire, first thing we had to do was we had to get payroll, accounting, and HR in the same room. Because each department's going to have a continued obligation for this. Accounting needed to figure out who we paid 1099s to, who we paid 1099s to that doesn't have employees, and where we sent their 1099s. They had to come armed with that information, and then they had to create a procedure going forward so that we can, when we send out a W-9 to get the information for the 1099, we're gonna send out another form that also asks them if they have employees, so that we can have our backup to why we chose them or why we didn't. So then we got that number. Payroll had to, what we did was we used, because we're small and we don't have a lot of fluctuating employment, so we didn't have to worry about average workforce and all of that. We took our W-2s from last year, and that was the number we used as our workforce. We are under the 25. So then I had to calculate and fill the form out for each employee. And in this section on page 2, where you break out what the employer pays and what the employee pays, I just left ours blank because we weren't responsible for the 60% and put the 40% in theirs. The biggest question I had from every employee was, what does this mean to me? How does this affect me? So I broke out and I did individual meetings with each employee so that I could show them dollar for dollar what they were gonna pay, because 40% of 82.5% of 0.63% means nothing to them. So I would take it and I would show them the math so that they knew each pay period, $1 extra is going to be taken from my check. And for the majority of them, it was under $5. So none of them had a problem with it. It wasn't until you got further up in the company that it became more, and I think it capped at $10 a pay period. So none of them were having an issue with this. The next question they would start asking me was about stuff that's happening in 2021. How is this going to be monitored? How are we going to stop abuse? And I can't answer that because we have no control over that. But those were the two big questions I had. So our takeaway would be to make sure that you have documentation backing up who you're counting as a 1099, because that's going to be key if you're ever audited to support why you chose them. And then the next one is to make sure your workforce is right, and to talk to the employees and just explain to them that this is the dollar, this is what it's going to cost you, this is what you're going to get. And they all seem to be okay with it. So it wasn't as big of a deal for any of our workforce. Any questions? Let me walk back to you.
Well, I have a question.
Okay,
So if we have employees and we start taking the deduction, and they're no longer with us in 2021, the money that they have contributed, what happens to that money? Do they take it to their next position in the company? Or?
So the money that's being contributed is funding a whole pool of money. It's not individualized. So the money in this pool will cover any employee anywhere in Massachusetts. So it's not like it's their money. It's not like Social Security where you're tracking it. So in essence, they can take from that money in another employer because it's just a pool.
So a follow-up to that question then is, if they've worked that minimum, I think it's 15 weeks before they start, then they could go on family leave and they could take the full amount, even though they've only contributed a small portion of that amount. They still get the full amount paid.
Correct. So there is no, because it's not employer-based what they get, as long as they've worked that period, then they get all of it.
How did you do that calculation of this percent of this percent of this percent? Is there a calculator?
So there's two, on the Mass website, there is a calculator, which, like I said, on our email that we send out, if you've registered for this event, then we have your email. If you haven't, there's a paper over there to put your email on. We're going to link to the calculator on the website, which will make it easy for you. I did it in Excel because my base is accounting, so that's why my brain works. But it's easy. The calculator on the website is super easy.
Is it up there now?
It is.
I don't know if this has to do with what we're talking about, but I think we were going to talk about who counts as covered individuals.
The covered individuals are your employees, and if you have to count the 1099s, that's why it's covered in individuals, not just employees.
So can you just give an example of a 1099 person how would they get those benefits?
So, well, they go through the state. To get the benefits, they go through the state. But what I do to tell the 1099 contractors that I'm going to be taking this is when they sign their contract with us, they have the form that's in your packet that is attached to their contract. And it says this is gonna come out if you qualify, if you have more than 51% of your workforce. And then what I'm doing is I'm gonna put a credit memo or something to show on their stub, you know how you get the 2 pieces to your check? On the top, it'll show this is how much we paid you, but we took this out for the paid family medical leave.